The Supreme Court chamber fell silent. Representative Jasmine Crockett stood behind the podium, her crimson blazer blazing against the deep mahogany walls of the highest court in the nation. The echo of Justice Brett Kavanaugh's brief, derisive laughter still lingered in the air, a short, cutting sound that fractured the solemn rhythm of the proceedings. For a heartbeat, time seemed to stop. The 9 justices, the packed gallery, the reporters hunched in the back, all turned their attention toward the unexpected confrontation unfolding before them. Kavanaugh leaned back in his high-backed chair, a trace of amusement still curving his lips. Appointed by former President Trump in 2018 after one of the most turbulent confirmation hearings in American history, he now sat as a cornerstone of the court's conservative bloc. His laugh wasn't mere noise, it was a signal, sharp and unmistakable: dismissal. But Jasmine Crockett didn't so much as blink. The freshman congresswoman from Texas, a former public defender known for her fearlessness and precision, inhaled slowly. What happened next would not only silence Kavanaugh's laughter, it would shift the tone of the entire hearing and ignite a national conversation that would echo through the legal community for months. Before we continue with this momentous clash, the narrator's voice might say, "Don't forget to like this video and subscribe for more in-depth coverage of the political showdowns reshaping America." The tension between Justice Kavanaugh and Representative Crockett had been simmering long before this day. Brett Kavanaugh, now 59, had spent his life climbing through the ranks of the conservative legal world. A Yale law graduate, he cut his teeth on Kenneth Starr's investigation into President Clinton before joining the Bush White House and later ascending to the D.C. Circuit Court of Appeals. His Supreme Court confirmation was a national spectacle, a bitterly divided ordeal that left deep political scars. In the years since, Kavanaugh had become a predictable conservative voice on matters of executive power, regulatory restraint, and especially voting rights, where he consistently sided with narrowing the reach of federal protections. His philosophy was rooted in textualism and originalism, reading the Constitution as it was understood when written. Though occasionally labeled a moderate among his peers, his votes often told another story, one favoring restriction over expansion when it came to federal oversight of elections. Jasmine Crockett's journey couldn't have been more different. At 43, the Texas Democrat had built her career in the trenches of criminal defense and civil rights law. Born in St. Louis and representing Texas's 30th congressional district, she'd defended activists during the Black Lives Matter protests and fought relentlessly against what she called modern voter suppression tactics. Her election to Congress in 2022 marked the rise of a new kind of progressive, sharp, fearless, and armed with data. Now, as a friend of the court, she had been granted 10 minutes to speak in the landmark case, Williams vs. Election Commission of Georgia, a case challenging Georgia's 2023 Election Integrity Act. Supporters of the law claimed it strengthened security by tightening ID rules, restricting ballot drop boxes, and giving the state greater control over local election boards. Critics like Crockett argued it was nothing less than a strategic assault on minority voting power, a modern echo of past injustices. Her argument was direct and data-driven. She presented the court with clear evidence that voter turnout in predominantly black districts had already fallen by 17% after the law's enactment. "This isn't a hypothetical," she began firmly. "We have verifiable data showing these restrictions target and harm minority voters in measurable ways." As she displayed a chart detailing the disparate effects on rural black communities, Justice Kavanaugh leaned forward, his expression skeptical. "Representative Crockett," he interrupted smoothly, "the Constitution grants states broad authority to regulate elections. Are you suggesting that this court should override the judgment of a democratically elected legislature?" Without missing a beat, Crockett replied, "Justice Kavanaugh, I'm suggesting that this court uphold the Voting Rights Act, which explicitly prohibits any practice that results in racial discrimination, intentional or not. The evidence before you demonstrates exactly that." Her words were measured, calm, until Kavanaugh exhaled a short laugh, shaking his head. Crockett paused. "Something amusing about the data, Justice Kavanaugh?" she asked evenly. The air in the chamber shifted. Behind her, voting rights advocates exchanged glances. Reporters leaned forward. Even Justices Kagan and Sotomayor straightened in their seats. Chief Justice Roberts glanced toward Kavanaugh, unreadable. Kavanaugh's faint grin lingered. "Apologies, Representative," he said lightly. "I just find it curious how often these studies manage to discover discrimination wherever they look. It seems the conclusions come first, and the data follows." The tension deepened. His comment wasn't merely skepticism, it was a challenge to Crockett's credibility. Adjusting her glasses, Crockett met his gaze. With respect, Justice Kavanaugh, healthy skepticism is welcome. Dismissive laughter, however, is not. These findings were gathered by a bipartisan commission and verified by 3 independent research institutions. She gestured toward her stack of documents. The methodology is detailed on page 27, should you wish to revisit it. The implication hung heavy. Had Kavanaugh actually read the brief? He shifted in his seat. I've reviewed it, he said tersely, but correlation doesn't prove causation. Voter participation fluctuates for countless reasons. That's true, Crockett replied, voice steady, which is why we accounted for those variables. She lifted another chart. This data compares turnout in demographically identical precincts, across county lines. The only difference? The voting restrictions in question. Justice Alito interjected, coming to Kavanaugh's aid. Even if there's some disparate impact, Representative, the state has an interest in preserving election integrity. Voter confidence is vital to democracy. Crockett inclined her head respectfully. Justice Alito, that argument would hold if there were any significant evidence of voter fraud. In the last 5 election cycles in Georgia, there have been 7 proven cases out of over 25 million votes. 7. That's 1 case per 3.5 million ballots. She paused, letting the absurdity sink in. We are disenfranchising thousands to stop a problem that barely exists. Justice Clarence Thomas spoke next, his voice deliberate. The Constitution entrusts states with regulating elections, Representative. Are you asserting that any statistical disparity automatically violates the Constitution? No, Justice Thomas, Crockett answered without hesitation. I'm asserting that when officials design procedures, knowing they will create racial disparities, and proceed anyway, that violates both the Voting Rights Act and the Equal Protection Clause. She raised a folder, and we have proof of that intent. The gallery rustled. All eyes fixed on her as she opened the folder. These are internal emails from the Georgia Election Commission, obtained through discovery, she continued. They explicitly discuss how certain provisions, like the new ID requirements and reduced early voting days, would suppress turnout in targeted communities. Kavanaugh's face hardened. He hadn't seen these documents. Across the courtroom, the commission's attorneys shifted uneasily. I direct the court's attention, Crockett said clearly, to page 14. Commissioner Williams writes, quote, the ID rule and reduced early voting will cut turnout in Atlanta and Savannah without touching our base counties. End quote. A wave of silence swept through the chamber. Kavanaugh shuffled his papers, looking for the referenced email. Crockett pressed on. This law isn't about election integrity, she said, voice unwavering. It's about electoral advantage, and the Voting Rights Act was written precisely to stop this kind of calculated disenfranchisement. Justice Amy Coney Barrett spoke up. Representative Crockett, these emails are concerning if accurately represented. But couldn't one argue that partisan advantage is different from racial discrimination? Political parties have always designed rules they believe benefit their voters in theory. Yes, Justice Barrett Crockett acknowledged. But in practice, no. Not when race and political affiliation are so closely intertwined in specific regions. The commissioners knew exactly which communities would be affected. These weren't race-neutral decisions with unintended consequences. They were deliberate choices with known impacts. Crockett turned back to Kavanaugh, who'd found the email exchange in question. Justice Kavanaugh, you've written extensively about the importance of clear congressional authorization for agency actions that have major economic or political significance. Doesn't that same principle apply here? Shouldn't we require clear evidence of a compelling state interest before allowing regulations that fundamentally alter who can participate in democracy? Kavanaugh looked up, meeting Crockett's gaze. This was a clever move using his own judicial philosophy against him. The situations aren't perfectly analogous, Representative. Perhaps not perfectly, Crockett agreed. But both involve the core question of who gets to make decisions that affect fundamental rights. If executive agencies need congressional authorization for major decisions, shouldn't states need compelling evidence before implementing restrictions that affect the most fundamental right in a democracy, the right to vote? Justice Kavanaugh started to respond but paused. The parallel was more effective than he'd initially realized. His own opinions on executive overreach had created a logical framework that could be applied to this case. Let me address your earlier point about the statistics, he said instead, redirecting the conversation away from his own judicial philosophy. Even accepting your data at face value, isn't this a question better addressed by Congress updating the Voting Rights Act rather than this court intervening in state election procedures? Crockett's response was immediate and forceful. Justice Kavanaugh, Congress did address this multiple times. The Voting Rights Act, as originally passed and subsequently amended, specifically prohibits any voting practice that results in a denial or abridgment of the right of any citizen to vote on account of race or color. The voting rights law doesn't require waiting for Congress to pass a new law every time states find a new method of discrimination. She stepped closer to the podium, her voice steady but passionate. This court's decision in Shelby County Volder eliminated pre-clearance requirements that would have prevented these exact types of changes. Having removed that protection, the court now has an even greater responsibility to enforce the remaining provisions of the Voting Rights Act. Otherwise, we're telling American citizens their most fundamental right depends entirely on which state they happen to live in. Chief Justice Roberts, sensing the tension, attempted to steer the argument back to legal principles. Representative Crockett, what standard would you have this court apply? Every election regulation will impact some voters more than others. The standard already exists in the law, Chief Justice, Crockett replied. Section 2 of the Voting Rights Act prohibits any voting practice that results in the denial or abridgment of voting rights based on race. The test isn't whether some theoretical voter might be affected. It's whether real voters are being denied equal access to the ballot. She turned back to Kavanaugh. Justice Kavanaugh, you've written about the importance of clear rules in election law to prevent uncertainty and litigation. But what's clearer than statistical evidence combined with explicit statements of intent? If that doesn't meet the threshold for Voting Rights Act protection, what possibly could? The question put Kavanaugh in a difficult position. His previous writings on election law had emphasized the need for clear administrable standards, exactly what Crockett was now offering. As the tension in the chamber reached its peak, all eyes remained fixed on this unexpected confrontation between the freshman representative and the Supreme Court justice. With a fundamental question of voting rights hanging in the balance, Kavanaugh straightened in his chair, gathering his thoughts. The chamber remained silent, waiting. When he spoke, his tone had changed subtly, more measured, less dismissive. Representative Crockett, you've raised valid concerns about the impact of these regulations. But I'm still troubled by the constitutional division of responsibilities. The Elections Clause gives primary authority to state legislatures. Crockett nodded, acknowledging his point while preparing her response. Justice Kavanaugh, you're absolutely correct about the Elections Clause, but that same Constitution was later amended specifically to protect voting rights regardless of race. The 15th Amendment wasn't a suggestion. This is a command that fundamentally altered the original Elections Clause calculus. She reached into her folder and pulled out another document. And this brings me to a point I believe you'll find particularly relevant. The gallery leaned forward. What else did she have? In 2006, you were deeply involved in their authorization of the Voting Rights Act while serving in the Bush administration. In fact, she continued holding up the document. I have here your memo to the President from May 2006 where you wrote, and I quote, "The Voting Rights Act has been a critical tool in eliminating racial discrimination in voting. Its protections remain necessary, and the evidence gathered by Congress demonstrates the ongoing need for these provisions." A murmur ran through the courtroom. Kavanaugh's eyebrows raised slightly in recognition. It was indeed his memo, one he hadn't thought about in years. Your memo continues. While significant progress has been made, their court before Congress contains substantial evidence of continued discrimination. The administration should support reauthorization of the existing provisions. Crockett, let the words hang in the air for a moment before continuing. Her voice calm but resolute. Judge Kavanaugh, I'm not asking you to adopt a new position. I'm asking you to stand by the position you already took when you carefully reviewed the evidence and advised the President of the United States. The Voting Rights Act's protections were necessary then, and with Shelby County having removed pre-clearance requirements, Section 2's protections are even more vital now. The courtroom was absolutely still. Kavanaugh looked down at his notes, then back at Crockett. The dismissive attitude from earlier had vanished completely. That memo was written in a different context, Representative, he said. Finally, different context, same principle, Crockett replied without missing a beat. The principle that voting is a fundamental right that requires robust protection. The principle that evidence of discrimination must be taken seriously. The principle that the Voting Rights Act means what it says. She placed both hands on the podium, leaning forward slightly. Justice Kavanaugh, when you wrote that memo, you weren't acting as a partisan. You were recognizing a fundamental truth about our democracy, NESB, that it only works when everyone has equal access to the ballot. I'm asking you to recognize that same truth today. Justice Elena Kagan, seeing the opening, jumped in with a question directed at Kavanaugh. Justice Kavanaugh, given your previous position on the necessity of the Voting Rights Act, what standard of evidence would you consider sufficient to demonstrate a Section 2 violation? It was a masterful move. MI5 forcing Kavanaugh to articulate a standard in real time using his own previous position as context. The ball was squarely in his court. Kavanaugh paused. aware that his answer would likely influence the direction of the court's decision. I would look for clear statistical evidence of desperate impact combined with an assessment of the state's justification for their regulation in question. Precisely the evidence before us today, Crockett interjected, seizing the moment. The statistics show clear disparate impact and the state's justification. Ian's preventing voter fraud as no evidentiary basis. She pulled out her final exhibit, a chart comparing voter participation across different demographic groups before and after the Georgia law took effect. What we see here isn't just a slight decrease in participation. We see a dramatic drop in specific communities, while others remain virtually unaffected. Combined with the email evidence of intent, this is exactly the scenario the Voting Rights Act was designed to prevent. Justice Sotomayor nodded. Representative Crockett, you've made a compelling case that goes beyond theoretical arguments to real-world impact. Kavanaugh, recognizing the shift in momentum, made one final attempt to regain footing. Even accepting these impacts, Representative, shouldn't we defer to state legislators to correct these issues? Judicial intervention should be our last resort. Crockett smiled slightly. Justice Kavanaugh, with respect, judicial intervention is precisely what the Voting Rights Act calls for. Congress specifically empowered the courts to act as a check on state voting regulations that result in discrimination. That's not judicial overreach. That's fulfilling the exact role Congress assigned to the judiciary. She looked around the chamber, making eye contact with each justice. In turn, the right to vote isn't just another policy preference. It's the right that protects all other rights. When state legislatures enact measures that they know will disenfranchise specific communities, they're not just harming those voters. They're undermining the very foundation of our representative government. Turning back to Kavanaugh, she delivered her closing argument. You began our exchange with a laugh, Justice Kavanaugh. I understand skepticism you nated. It's essential in your role. But I ask you to be skeptical, not just of those fighting for voting rights, but also of those restricting them. Examine their claims with the same rigor. Ask for their evidence with the same intensity. And most importantly, hold them to the same standard you articulated in 2006 when you recognized the ongoing necessity of the Voting Rights Act's protections. The Chief Justice looked at the clock. Your time has expired, Representative Crockett. She gathered her papers. Thank you for the opportunity to address the court. As Crockett returned to her seat, the gallery remained silent, processing what they had just witnessed. Kavanaugh sat motionless, his earlier dismissive attitude completely transformed. What had begun with his derisive laughter had ended with him confronting his own previous positions on voting rights. The momentum had shifted visibly, not just in the case, but potentially in the court's approach to voting rights cases more broadly. In that moment, it was clear to everyone present. Jasmine Crockett hadn't just responded to Kavanaugh's laugh. She had fundamentally altered the conversation about voting rights in America's highest court. The immediate aftermath of the Crockett-Kavanaugh exchange sent ripples through both legal and political circles. Outside the Supreme Court building, reporters clustered around legal experts seeking analysis of what they just witnessed. In 30 years of covering the court, I've rarely seen a justice so effectively challenged on their own record, remarked Nina Totenberg, the veteran legal affairs correspondent. Representative Crockett didn't just argue the law. She made Justice Kavanaugh confront his own previously stated principles. Conservative legal commentator Carrie Severino offered a different perspective. Crockett's performance was impressive, but the fundamental question remains whether federal courts should substitute their judgment for state legislatures on election procedures. Social media exploded with reactions. The hashtags number Crockett, Kavanaugh hand number voting rights showdown began trending nationally. Though cameras weren't allowed in the courtroom, artists' renderings of the moment Crockett held up Kavanaugh's memo circulated widely, becoming an instantly recognizable image. By evening, the confrontation had made headlines across major news outlets. CNN's banner read, Representative Crockett challenges Justice Kavanaugh with his own words on voting rights. Fox News took a different angle. Freshman rep brings political theater to Supreme Court arguments. The New York Times analysis was more measured. Unexpected exchange between Kavanaugh and Crockett highlights evolving voting rights jurisprudence. But beyond the immediate media response, the exchange had deeper implications for the case itself. Legal experts noted a significant shift in questioning after Crockett's presentation. When Georgia Solicitor General rose to defend the state's law, Justice Kavanaugh's questions were noticeably more pointed. What specific evidence of voter fraud prompted these measures? He asked, echoing Crockett's earlier challenge. Later he pressed further. How do you respond to the email suggesting partisan advantage was a motivating factor? 3 days after the oral arguments, A leaked memo from a conservative clerk to one of the justices made its way to Politico. According to the memo, Kavanaugh was reconsidering his position and had requested additional briefing on the statistical evidence presented by the plaintiffs. While unconfirmed, the leak suggested Crockett's confrontation had potentially swayed a key vote. 2 months later, when the court issued its ruling, legal analysts were stunned. In a 5-4 decision written by Chief Justice Roberts, the court struck down key provisions of Georgia's law. Most surprisingly, Kavanaugh had joined Roberts, Barrett, Kagan, and Sotomayor in the majority. In his concurring opinion, Kavanaugh directly addressed the issues Crockett had raised. While the Constitution grants states significant latitude in regulating elections, he wrote that authority is not unlimited. When regulations produce substantial disparate impacts, and when those impacts are foreseeable and potentially intentional, heightened scrutiny is appropriate under both the Voting Rights Act and the 14th Amendment. Even more remarkably, Kavanaugh cited his own 2006 memo. As noted when advising on their authorization of the Voting Rights Act, evidence of discrimination in voting practices remains a reality that courts cannot ignore. The judiciary's role is not to substitute its judgment for that of state legislatures, but neither can it abdicate its responsibility to protect fundamental constitutional rights. The impact extended far beyond the immediate case. State legislators across the country, many of which had been considering similar election laws, paused their efforts. Legal challenges to existing restrictions gained new momentum, citing the court's reasoning in Williams v. Election Commission of Georgia as precedent. For Representative Crockett, the aftermath was transformative. Once known primarily in progressive circles, she became a national figure overnight. Interview requests poured in. Law schools invited her to speak. The Congressional Black Caucus appointed her to lead a special task force on voting rights. What Representative Crockett achieved wasn't just a legal victory, explained constitutional law professor Lawrence Tribe. She created a moment that forced a Supreme Court justice to reconcile his current positions with his property. Past statements. That's extraordinarily rare and potentially consequential for future cases. Conservative legal scholars were less enthusiastic. This decision represents judicial overreach, argued former Attorney General William Barr. States have traditionally had wide latitude in election administration. This ruling significantly narrows that authority. 6 months after the decision, as states adjusted their election laws to comply with the new president, Crockett and Kavanaugh found themselves at the same Washington legal forum, approached by reporters hoping for another dramatic exchange. Both were professional, but reserved. Justice Kavanaugh and I have different perspectives on many issues, Crockett acknowledged. But I respect his willingness to engage with evidence and to apply legal principles consistently, even when doing so might not align with his preferred outcome. Kavanaugh, typically reticent with the press, offered a brief response. Representative Crockett presented her case effectively. The court's role is to apply the law to the facts before it, regardless of political considerations. The most significant legacy, however, was felt in communities previously affected by restrictive voting laws. In the following midterm elections, turnout increased dramatically in many minority communities. Election officials reported smoother voting experiences with fewer rejected ballots and shorter lines at polling places. Mary Jackson, an 82-year-old voter in Savannah who had struggled with previous ID requirements, summed it up. "For the first time in years, I didn't worry about whether they'd let me vote. I just voted." The Crockett-Kavanaugh confrontation became a case study in law schools nationwide. The exchange illustrated not just legal argumentation, but also the power of holding public officials to their own stated principles. It demonstrated how a prepared advocate could shift the trajectory of constitutional interpretation. Perhaps most importantly, it showed that America's ongoing struggle for voting rights wasn't merely an abstract legal debate, but a real-world battle with consequences for millions of citizens. The moment that began with Kavanaugh's dismissive law and ended with his decisive vote had changed not just a single case, but potentially the court's approach to voting rights for years to come. It reminded everyone that in America's system, no position is beyond challenge, no official beyond accountability, and no right more fundamental than the right to vote. As citizens returned to the polls under fairer rules in subsequent elections, many remembered the freshman representative who stood before the nation's highest court and refused to be silenced. The confrontation between Crockett and Kavanaugh hadn't just made for compelling political theater. It had strengthened American democracy itself. Thank you for watching our detailed breakdown of this historic confrontation. If you enjoyed this analysis, please like this video and subscribe to our channel. Hit the notification bell so you never miss our in-depth coverage of the political moments that shape our nation. Leave a comment below telling us which political confrontation you'd like us to